Ready, start. This gives rise to a fresh cause for examination of the evidence garnered at the investigation, so as to satisfy the court about the grave suspicion as arising from the material collated and enter upon a finding of prima facie case. Full stop. As pointed out by the learned senior counsel for the complainant, we see that the High Court, after making such observation, has proceeded to consider the matter on merits based on decisions of this court, delineating the scope for discharge, prior to a full-fledged trial. Full stop. It was also pointed out that the High Court has agreed with the observations made by the special court to proceed with the trial, and hence we have to necessarily consider the issue on merits. Full stop. As has been found by the special court, at the initial stage considering the discharge application, the court has to only prima facie, consider the material on record, and if a strong suspicion arises from the materials produced, that the accused has committed an offence, then there can be no sufficient ground for discharge. Full stop. Immediately, we have to notice that this is not the presumption under section 20 of the act, but only the prima facie satisfaction, based on the materials available with the court at the initial stage, so as to not appropriately discharge the accused, but proceed to examine the evidence in a full-fledged trial. Full stop. We have no quarrel with the above proposition, but we are unable to find any such material having been specified by the special court, in the present case, in its order, especially regarding even an accusation against the appellant herein, as to the demand of bribe for the purpose of making the grant of fishing rights. Full stop. In this context, we have to specifically notice that the allegation initially was only against the first accused, who was the Minister of State in the government of Gujarat. Full stop. There was an allegation that the complainant had delayed the initiation of prosecution, which we find to be not valid, especially since the complainant, after approaching the High Court, against the peremptory grants made of fishing rights, also had approached the state government for sanction to prosecute the Minister of State. Full stop. The state once rejected the application, and the petitioner moved a writ petition, and it was in compliance of the order passed therein that a sanction was granted to prosecute the Minister of State. Full stop. The complainant at no point of time had any allegation against the minister, the appellant herein, nor does the statement recorded at the pre-evidence stage before the special judge raise such an allegation. Full stop. The allegation was only that the Minister of State had granted the rights on an upset price, without following the government policy of 2004, thus causing loss to the state exchequer, running to crores of rupees. Full stop. The special judge refused to look at the statements recorded and jumped to the conclusion of a prima facie case made out. Full stop. The special judge refused to discuss the evidence placed before it by way of the statements and the investigation report, finding that there need not be any detailed evaluation of material on record, regarding the guilt of the applicants for considering an application for discharge. Full stop. The special judge referred to the voluminous inquiry report filed along with the documentary evidence, and opined that the grants were made on an upset price without following the policy of 2004 and without calling any tender, and ultimately the same were cancelled as per the order of Honorable High Court of Gujarat, within bracket 6 bracket close semicolon, which we have to pertinently observe is not an allegation either under section 7 or section 13 of the act, Full stop. The special judge then went on to look at the complaint, comma, wherein accused number 1 alone was blamed as responsible for making the illegal grants of reservoirs without calling tenders, comma, after demanding illegal gratification to be paid during the period of the grant, comma, which resulted in an abuse and misuse of the public office held by the Minister of State, full stop. It was again brazenly found, comma, without anything further, comma, based only on the statements recorded, comma, that the inquiry report establishes a prima facie case against the accused and that none of the parties thought it fit to cross-examine the complainant on this material point of fact, full stop. It was also found that the court had issued summons under section 311 against the three officers constituting the investigation team, considering the evidence of the complainant which remained unshaken, full stop. According to us, comma, the refusal to avail the opportunity to cross-examine cannot be put against the accused, comma, if actually there is no case coming out against them, full stop.